So Mr. Williams is the tenant under the lease. Haley Trevino is listed as an occupant. We submitted the lease as Exhibit 1. And it's our belief that Mr. St. Vilas is the party that is actually residing on the premises. He says he's leasing it from Miss Trevino, but when somebody from the property went to the unit, Mr. St. Vilas said he didn't know who Mr. Williams was. So it's our belief that neither Terry Williams or Haley Trevino are residing at 1601 East Slaughter Lane, and defendant St. Vilas is, along with potentially other occupants who we've not gotten the names of.
Okay.
But we brought this suit against all three, as Mr. Williams is the tenant under the lease and Haley or Ms. Trevino is a occupant, and St. Vilas is apparently living in the unit despite not getting landlord approval for any sort of sublease.
Okay. So it looks like we have a service return for Mr. Williams. We do not have service on one of these cases. But let's see. And then the other one, on the property itself, it was served 1601 East Slaughter Lane 138. So I guess it's Miss Tiffany Haley who didn't get served, I guess. Okay.
Mr.
Go ahead.
Did you say Ms. Trevino didn't get served?
Yeah, I don't know if she did or not.
It's our understanding.
Okay. My clerk, there's several documents in this file, so I have to open up one at a time. So then Mr. Williams, you're here. You don't know where Miss Trevino is right now, or he's not running errands, and then you didn't know who the Mr. St. Vilas is. But are you ready to go forward, or do you have any questions to start off with before they give me their testimony? Okay. Go ahead and proceed then, Ms. Bush. Why are you asking?
The end with from the.
Your signal seems to be kind of not real strong, Mr. Williams, because you cut out every now and then.
Yes, one sec. It says the court's bandwidth is low, but I'm sure it's not. 1 second.
I'm going to listen to Ms. Bush, and she's going to tell me why they're asking for possession of the property, and then you'll have a chance to respond, I guess, on your behalf and your co-defendants. Ms. Bush, what's going on behalf of the property?
So, Your Honor, we're here on an eviction petition for termination of a month-to-month tenancy for a lot for a manufactured home. So, a brief timeline of events. On October 6th, 2025, the landlord.
At first glance, this looks like a simple eviction case, but there's more going on beneath the surface. The landlord argues the lease was properly terminated and rent hasn't been paid for months. The tenant, however, insists there's a larger legal dispute involving retaliation and fair housing claims. The judge now has to decide one question: who has the stronger legal right to the property today?
Landlord delivered a 60-day notice to vacate, which is required under the lease and also complies with the Texas Property Code. This notice to vacate was sent hand delivery, first class mail, and certified mail. Sorry, 60-day notice of termination, not notice to vacate.
Okay.
And then January 16th, which was over 100 days later, the landlord delivered the 10-day notice to vacate, which is attached, or we've uploaded to the court as Exhibit 4. This was also sent hand delivery, first class mail, and certified mail. After 10 days, the defendant had not vacated or the defendants had not vacated the premises, so we filed this eviction petition on January 29th, 2026, which was 13 days after the 10-day notice to vacate was sent. And to date, defendants still have not vacated the premises. So because the landlord properly sent the notice of termination, sent the notice to vacate, where the landlord just seeking possession of the premises and recovery of the unpaid rent and our attorney's fees as permitted under the lease.
So what's the monthly rent?
$812.
$812 a month. And you're saying there's some rents that are also past due?
Yes, since October. So total rent past due is $4,060.
$4,060 in rent past due? And do you have a ledger to support that?
Yes, that is Exhibit 5, Your Honor, and I'm happy to share my screen if that's easier.
Okay. I have, well, what was submitted was were letter exhibits, but you're saying now your other exhibits, you numbered them?
Um, I have them as numbers, but if they're letters, it would be maybe E. I have it as Exhibit 5.
Okay, there's exhibit 2 is the non-renewal, which happened October 6th. So essentially y'all were terminated or not renewing the the lease for the lot, right?
Right. It was on a month-to-month lease because the primary lease expired. So pursuant to the terms, it would continue on a month-to-month basis.
Okay, 10-day notice on January 16th.
And the next exhibit would be the ledger after the 10-day notice to vacate. And you'll see community site rent.
I'm looking for the ledger real quick. There it is. Okay. So y'all have gotten payments or no?
No, the
You have-
last payment was September 22nd, 2025.
Of $900.
Yes.
Okay.
So we're seeking the community site rent of $812 for October through February.
Okay, so that's 812, right? Times 4
Times
for
5.
well, I would prorate February.
Okay,
So times 4 is 4 times the 812 is 3,248, right? And then I would prorate the 812 for February, 18 days divided by 28. That gives me 522. Add that to the 3248, and that gives me 3,770 in rent that wasn't paid, in addition to being a holdover, right?
correct, Your Honor.
Miss Murray, do you agree with that? The amounts that are due
Yes,
as
sir.
far as rent? Yes. Okay.
Yes, sir.
All right. Mr. Williams, are you still there?
Yes, I'm here.
Do you have any response to those allegations that rent hadn't been paid since October?
Yes, so there there is a discrepancy with the information that was provided to you, along with the citation that I received. Also, Your Honor, I filed a plea and abatement because there is a pending county court of law case involving possession, retaliation, and the Fair Housing Act claims concerning the same property, which those issues are outside the jurisdiction of the Justice Court.
Okay, but what they're asking for is possession of the lot. They're saying we want this mobile home, I guess, moved off the lot, right? Is that what y'all are wanting? Is this for the lot rent? This is not for the mobile home, but for the lot itself, right?
Just the lot, correct, Your Honor.
So, what case are you talking about that's pending? Do you know what he's talking about, Ms. Bush?
We've not been served with service of that citation, but we are aware of it.
Okay, so there's a case you filed against, I guess, Sun River Ridge, Mr. Williams?
Yeah,
When was that filed?
yes, sir. I have the case number. One sec.
When was that filed?
That was filed December 4th. December 4th, 2025.
And that hasn't been served yet on the community?
Yes, sir. I also came to your courthouse, sir.
Okay, and
A copy -CV-25-007730.
okay. So you're saying that there's a plea in abatement in this matter, that there is something else that needs to be resolved before I determine whether or not possession should be granted? Because
Yes, sir.
I said I have filed an answer. Where's the answer, Miss Diana? I don't see that. I see the email that he sent from T. Will on February 12th, but I don't see that. Where's the his answer? Oh,
The
there
court
it is.
also forwarded us that email, Your Honor. We called the court asking for a copy of the answer in the plea and abatement, and we were told that all that the court had received was the letter. We
Okay.
never received an answer or the plea and abatement.
Okay, I do see a defendant's original answer and plea and abatement. Um, what is why should I hold off on holding? This is not for ownership of, I guess, the mobile home. This is for the site, the mobile home site where the home is resting. So why shouldn't they get possession back of this? If this is actually on a month-to-month basis, there's no continuing lease, Mr. Williams, right? The lease has ended and it was on a month-to-month basis for quite some
As
time.
I previous as I previously mentioned, that like this housing act claims and you the property and the lot.
Okay, so are you the owner of the mobile home?
Correct.
And
So this is a possession.
have y'all offered to the rent and it just hasn't, and they have refused it, or what's going on as far as the rent for the lot?
So in July 14th, I made a complaint to the uh, president of the Sun communities, and there was an ongoing email exchange back and forth. Following our conversation, that regional manager at the time informed my legal counsel for a separate bankruptcy issue that she was terminating my lease, and that they wanted me like off of the property. With that being said, I was no longer able to like access the online pool, in which like the online payments continue making payments via money order. So I had been mailing certified money order payments for the rent. However, like with this community, they take money order payments, cash payments, and it's hard to see like how they would have a ledger when there's a lot of things just done under the table.
Well, it seems like a lot to sort out, and y'all may end up having to sort it out at county court, because what I'm looking at is that they haven't accepted any rent from you, or you haven't offered any rent, or haven't paid any rent for the last several months. Do you have proof that you've paid the rent by money orders?
Yes, sir. I have the certified letter receipts.
So has he sent in money orders that y'all are holding, Miss Murray?
No, Your Honor.
So, Mr. Williams, I don't know, where have you sent those money orders?
One second. So I received a letter from an attorney named Jackson Walker LLP, representing River Ridge Estates, and they informed me that to not communicate directly with the office, and any future rent payments should be sent to this attorney.
Okay. So are you holding those, Ms. Bush, at the law firm? Do y'all have them at the law firm?
Not that I'm aware of. If Mr. Williams could provide us with the specific attorney at Jackson Walker that said that, but I'm not aware of any of that, Your Honor.
Did you send those to Mr. Skaggs, Mr. Williams?
What is that? So yeah, so the name on the letters that I received was from Jack E. Skaggs. However, anytime I've sent mail to Jackson Walker, I just sent it to Jackson Walker LLP, and the address just included in the letterhead.
Okay. Well, it's Mr. Williams. What they've got to show me by a preponderance of the evidence is they're entitled to a great right of possession. And number one, that they said they've terminated the lease, and they gave you a 60-day notice of termination lease back in October. And here we are in February, and we're still with the issue of what they're saying, non-payment of rent and a holdover lease. So your lease was on a month-to-month basis. There's no continuing reassurance that they were going to continue to lease to you. And so I'm going to grant them possession of the property. It does sound like you're invested, and there's something else going on which you may address and be better prepared for at county court. But you're going to have to appeal this judgment if in fact what you're telling me is correct and true, and you're going to have to show proof of those things to the appellate court to support your position that you've sent those, that you've got those money orders.
This is the turning point. Mr. Williams says he mailed certified money orders after being told to send payments to the landlord's attorneys, but the property's representatives say they never received them. Without clear proof before the court, the judge has to rule based on the evidence available, not on what might be proven later. That's often how eviction hearings are decided.
Receipts, who you sent them to, where they've sent them to. But I mean, at this point, I think they met their burden of proof or preponderance of the evidence at this JP level to get possession back of the property. Now you have 5 days to appeal. So you've got 5 days until Tuesday of next week to file that appeal paperwork, post your appeal bond with that, and to perfect the appeal for it to go to county court. Otherwise, if you don't appeal by Tuesday, then the judgment will become final and they can take steps to move on that. Now, you said you had an attorney, and so I don't know if they're doing that at district court, but or if you have a bankruptcy attorney, that a bankruptcy could stay these proceedings. But right now, I don't have that in front of me. So I'm going to grant this judgment against the defendants that were listed in the petition, although I'm concerned about the other defendants, Miss Bush, Miss Trevino, and Mr. St. Villas, who don't have a lease with the defendants. There may be occupants of the property, but they're not liable to the rent to Sun River Ridge, are they?
Correct, Your Honor.
Okay.
Just so the possession would be against all defendants and rent being against Mr. Williams.
Right. So I'm going to grant the possession of the property from the defendants for Sun River Ridge, but the only ones that are liable for the rent under the lease is Mr. Williams. So do you have a proposed order that you want to provide us or that you've prepared, or do you want us to create our own?
In light of your ruling, I can easily prepare a proposed order.
Okay. All right.
But Your Honor, we would also like to seek our attorney's fees.
Okay. What are you asking for in attorney's fees? It's reasonable and necessary in this matter.
Our attorney's fees just from drafting the petition for this eviction onward, so not including any of the work done prior for the notice of termination or notice to vacate, is $6,794.
I don't know if that's reasonable and necessary in this matter, Miss Bush. 6,000. That's a lot. That's a lot of attorneys. How many hours are we talking about, and how many attorneys were involved in this?
So myself, Your Honor, I have spent about 8.9 hours on this matter, and Jack Skaggs, who is the partner overseeing this matter, has spent 2.3 hours. Sun River Ridge agreed to compensate Jackson Walker at the rate of $615 for my time and $895 for Jack Skaggs's time.
Okay. As far as attorney's fees, I'm going to grant $1,500 in attorney's fees. The back rent's at $4,060. No, sorry, $3,770, and then $1,500 in attorney's fees as reasonable and necessary in this kind of a matter. And we'll go from there. All right.
Thank you, Your Honor.
Thank you very much. Y'all are excused. And let's see. As far as the attorney's fees, do you know if the property is empty yet, Miss Murray, or are they still somebody living there?
I believe someone's still living there. Whenever we drive by, there's a car.
Okay.
Well, that's the thing. I own the mobile home. Of course, my stuff is still there. Like, there's a process.
Right.
To
Okay. So you have 5 days to appeal this, Mr. Williams.
remove a whole mobile home from a lot. And
well, allegedly they gave you a notice of termination.
Yeah, we'll do. I'll be
back in,
hopefully
back in October or whatever. So you've got 5 days from here to appeal the judgment.
I filed a civil law.
They haven't been served on that, and there hasn't been any motion to stay or to abate the case granted from a higher court. So I'm not. That's since I don't have it. I don't have it. So I'm basing my ruling on the evidence I have in front of me today. Okay. Y'all are excused, and I'm going to take the next case involving Montecito Apartments.
Thank you, Your Honor.
Thank you very much.
This is an eviction due to non-payment of rent. The lease itself was signed on March the 20th, 2025, provided for monthly rent in the amount of $1,497. A notice to vacate was sent on December the 10th, 2025, and a notice to vacate was sent because Ms. Drysdale had been late in April, June, August, September, October, and November, all of which occurred in the year 2025. The total amount of her past due rent is $5,624. That represents $171 for October, $1,497 for November, December, and January. February was prorated and is an amount of $962. Ledger balance is $7,000 plus. And we're seeking back rent, possession of the property, and interest, but no attorney's fees.
Okay. So, Miss Miss Griffiths Drysdale, it says here your rent's a $14.97 a month, and you've been behind for some time now. Did you get a notice to vacate from them asking you to move out over that
Um,
apartment?
yes, I did. I went and spoke with the office. So what happened was I got pregnant. I was in a high risk pregnancy, so I wasn't working for quite some time. I spoke with the office. They were giving me time to catch up on everything. I believe that was in December or November. Um, yeah, so that's basically what happened. She contacted me, I believe late January or early January to ask me, what I was going to do because I had the back rent and everything. I told her that I did intend to pay and to resign my lease in March. I filed my taxes on February the 4th, which is going to suffice to cover all of my back rent and should be able to get me to re-sign my lease and pay the month of March if they're giving me the opportunity to do so. But I wasn't able to upload that because I only got this notice 2 days ago. So I didn't get the notice for this hearing
Hearing.
until Monday.
Okay, well, it looks like it was attached to your door at apartment 128, 301 Parker Lane back on the 9th of February. Today's the 18th. Have you not been at home?
So yes, I am here. I work from
Okay.
home, so I'm here all the time.
Okay. Well, they attached this notice that, back on 9 days ago. You didn't get
Understood.
it 9 days ago. You got it in the mail instead, or what?
Yeah, so I did get the notice from 9 days ago. I didn't realize what it was until because they attach stuff to our door all the time. But when I saw the notice in the mail on Monday when I picked everything up, I realized that I had this meeting today and I
Okay.
had to submit the stuff 3 days prior.
Okay. So, I don't know what arrangements you have separate with the property at the office,
Mm-hmm.
but whoever they have to answer to has hired this law firm to file for this eviction to get possession back because they don't think you're going to be able to come up with the $7,000 that's on your ledger.
Understood.
Now, in this case, in rent, in an eviction case, all they can get is back rent plus the court costs, possibly attorney's fees. They're not asking for attorney's fees today, but they're asking for the back rent. And based on what Mr. Hedrick testified to, that there's a balance from October, and then November, December, January haven't been paid, and then the prorated amount from February is today is 962. So add those together, and I've got 5,624, which is less than what's on your ledger because this is the rent only. Okay, and there's no late fees in there. There's no utilities, but talk with the property. Uh, if they've got another arrangement with them, make sure you get it in writing. But because right now I'm going to have to grant the possession of the property.
Understood.
Okay. And I don't know when you believe your taxes are coming back, or if they're saying, hey, we'll wait to get a writ of possession if by a certain date, but I don't know. We're going to send you a copy of the judgment. And so you have 5 days from today to appeal this judgment or be out of the property or have that arrangement that they've accepted that you have in writing that you're going to pay whatever you owe to stay and re-sign a lease. But I'm sorry you've had that high risk pregnancy. You had your baby?
I did. He was born in October, underweight,
Oh,
but he's
okay.
healthy now.
Okay. And so you working now or are you getting
Yes, I
assistance?
restarted working January the 12th.
Okay. All right. So evictions are not anything anybody likes to do, but that's what they are wanting to try to, you know, or to protect their interests, their financial interests. So it's a contract, and one of the remedies in the contract, if you don't abide by the terms, then they can get one of the remedies, which is possession back. So it sounds like you got a good head on your shoulders. You understand the process, and that you don't look you don't look real worried. But I mean, I would be concerned, and to make sure you talk with the property and let them know where you stand, and let them know what they expect. Otherwise, I don't want you to.
In the end, the judge granted possession of the property to the landlord while reminding both tenants that an eviction judgment isn't always the end of the road. If they believe important evidence was overlooked, they still have the right to appeal within the legal deadline. Cases like these show how quickly missed payments, paperwork, and legal procedures can determine who keeps possession of a home. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.